Hello Year 12s and welcome to the first of 4 videos on key concepts in the Victorian criminal justice system. Outcome 1 of Unit 3 focuses on the Victorian criminal justice system, and the purpose of these 4 videos is to familiarise you with some of the key concepts that relate to that system. Many of these concepts have been covered in Year 11, so much of this should simply be revision, but it's important revision nonetheless. Having said this, there is some new information that we didn't cover in Year 11, and so you will need to take careful notes about this new information. There are 4 things that you need to do while you're watching this video. First, take the very best Cornell notes that you can. Second, use the pause, rewind, and fast forward functions. Pause if you need time to take notes. Rewind if you think you've missed any information and want to listen to it again. And fast forward if you already know the information and feel that you don't need to listen to it again. The third thing that you need to do is have your vocabulary sheet open in front of you so that you can include in it definitions of any important terms or definitions of words that you're unfamiliar with. And the final thing that you need to do is have your summary books open in front of you. As we go through this video, I will give you some guidance as to what to include in your summary books. When you've finished watching this video, please read the pages from the textbook that are referred to on the front of this slide, and then supplement your notes with any information from that reading that you think might be useful. All right, let's make a start then. This slide sets out our learning intentions for this video. Our first learning intention is that you need to be able to define the 3 types of criminal offences. Our second learning intention is that you need to be able to distinguish between summary offences and indictable offences. Write these learning intentions down in your Cornell notes. The 3 types of criminal offences or crimes are summary offences, indictable offences, and indictable offences heard and determined summarily. Summary offences are the least serious kinds of criminal offences. A summary offence is a minor criminal offence that is generally heard in the magistrate's court. In the magistrate's court, there is a magistrate but no jury. Look down the left-hand side of your vocabulary sheet, find the term summary offence and write this definition in opposite that term. Once you've done that, highlight the words minor and magistrate's court. Whenever you define the term summary offence, make sure that you include these highlighted words in that definition. In contrast to summary offences, indictable offences, which is spelt indictable offences, but is pronounced indictable offences, are more serious kinds of criminal offences. An indictable offence is a serious criminal offence that is generally heard in the county court or Supreme Court before a judge and jury. Again, look down the left-hand side of your vocabulary sheet, find the term indictable offence and write this definition in opposite that term. Once you've done that, highlight the words serious, county court and Supreme Court. Whenever you're required to define the term indictable offence, make sure you include these highlighted words in that definition. Unlike in the magistrate's court, there is a jury for all criminal trials in the county court and the Supreme Court. Well, what then is the distinction between a summary offence and an indictable offence? There are 2 significant differences between summary offences and indictable offences, and you can see these from the definitions included on this slide. First, a summary offence is a minor criminal offence, whereas an indictable offence is a serious criminal offence. Second, a summary offence is generally heard in the magistrate's court, where there's a magistrate but no jury, whereas an indictable offence is generally heard in the county court or the Supreme Court before both a judge and a jury. In the next video, I'll explain in more detail the roles of a magistrate, judge and jury in a criminal case. However, at this stage I want to emphasise that you must not confuse a magistrate and a judge. While they perform similar roles, and while both magistrates and judges hold legal qualifications, magistrates are only found in the magistrates' court and not in the county court or Supreme Court, and judges are only found in the county court and Supreme Court and not in the magistrates' court. In between these two kinds of offences, in terms of seriousness, is indictable offences heard and determined summarily. An indictable offence heard and determined summarily is an indictable, that is, a serious criminal offence, that can be heard in the magistrate's court as if it was a summary offence. Look down the left-hand side of your vocabulary sheet, find the term indictable offence heard and determined summarily, and write this definition in opposite that term. Then highlight the words indictable, can, magistrate's court, and summary. Again, when you're defining the term indictable offence heard and determined summarily, make sure that you include each of these highlighted words in that definition. Now, there are two conditions that must be satisfied for an indictable offence to be heard and determined summarily. That is, for the indictable offence to be heard and determined in the magistrate's court without a jury, rather than in the county court or the Supreme Court where there is a jury. The first of these conditions is that the magistrate must be satisfied that it is appropriate to determine the case summarily. In determining this question, that is, in deciding whether it is appropriate to determine the case summarily, the magistrate must take into account both the seriousness of the offence and the adequacy of the sentence that the magistrate can impose. Here, it's relevant to note that a magistrate can only impose a term of imprisonment of up to 2 years for one offence and of up to 5 years for multiple offences. So, for example, if the magistrate decides that if the accused is found guilty of the offence, then an appropriate punishment would be imprisonment for a term of greater than 2 years, let's say 6 years, then the magistrate is likely to decide that it is not appropriate to determine the case summarily. Instead, it would be more appropriate for the case to be determined in the county court or the Supreme Court, where if the accused is found to be guilty, then the judge can impose a term of imprisonment of around 6 years. The second condition is that the accused must consent to the case being determined summarily. This is necessary because, in having their case determined summarily, the accused is giving up their right to a trial by jury. As you know from our video on the rights of an accused, where an accused is charged with an indictable offence and pleads not guilty, then the accused is entitled to have a jury trial. However, there's no jury in the magistrate's court. Having said this, an accused might be prepared to give up their right to a trial by jury if, for example, the case is one where the prosecution might be able to influence the emotions of the jury so that it's more likely that the jury would find the accused to be guilty. An example of such a case might be where the accused is charged with sexual offences against children. In such a case, the accused might feel that they have a better chance of being found not guilty where their case is heard by a magistrate rather than a jury. Now, it's also important to realise that not all indictable offences can be heard and determined summarily. Generally speaking, an indictable offence can only be heard and determined summarily if it is an offence that is punishable by a maximum of up to 10 years imprisonment or by a maximum of up to 1,200 penalty units in fines. One penalty unit currently equates to $192.31, and so 1,200 penalty units is the equivalent of around $230,000. So, for instance, murder, which is punishable by up to life imprisonment, and rape, which is punishable by up to 25 years imprisonment, can never be heard and determined summarily because the maximum punishments for those crimes are greater than 10 years imprisonment. Now, a word of warning. Please use the definitions of summary offence, indictable offence, and indictable offence heard and determined summarily that I've given you. It is not correct, for example, to define a summary offence as an offence that is only punishable by a fine and not imprisonment. It is not correct to define an indictable offence as an offence that is punishable by more than 10 years imprisonment. And it is not correct to define an indictable offence heard and determined summarily as an offence that is punishable by up to 10 years imprisonment. These are common mistakes that are made by students. By way of summary, this slide sets out the hierarchy of courts in Victoria and the types of criminal offences that they can deal with. As we've seen, the Magistrates Court deals with summary offences. In the Magistrates Court, there is no jury, and it is for the magistrate to determine whether the accused is guilty or not guilty of the summary offence. If the magistrate decides that the accused is guilty of the summary offence, then the magistrate must go on to decide what punishment to impose on the accused for committing that summary offence. In contrast, the County Court and the Supreme Court, or more specifically the Trial Division of the Supreme Court, deal with indictable offences. While the County Court and the Trial Division deal with the same types of indictable offences, only the Trial Division can deal with murder cases. In the County Court and the Trial Division of the Supreme Court, there is a jury, and it is the jury that is responsible for deciding whether an accused who pleads not guilty to an indictable offence is in fact guilty or not guilty of that offence. If the jury decides that the accused is guilty of the indictable offence, then it is for the judge to decide the punishment to impose on the accused for committing that offence. However, some indictable offences are indictable offences that can be heard and determined summarily. These types of indictable offences can be heard in the County Court or the Trial Division of the Supreme Court because they are indictable offences. In such a case, they will be heard by a judge and jury. Alternatively, these types of indictable offences can be heard in the Magistrates Court if the magistrate is satisfied that this is appropriate and if the accused consents. In such a case, the magistrate decides both the guilt of the accused and the punishment to be imposed on the accused if the magistrate decides that the accused is guilty of committing that offence. But remember, the accused does not have to consent to their indictable offence being heard and determined summarily in the Magistrates Court. Instead, the accused can decide to have their trial in the County Court or the Trial Division of the Supreme Court with a jury. This slide sets out examples of the three different kinds of criminal offences, that is, summary offences, indictable offences heard and determined summarily, and indictable offences. I suggest that you pick two examples from each category of criminal offence and learn these. A number of summary offences are set out in the Victorian Summary Offences Act 1966. Examples of summary offences include traffic offences such as speeding and offensive behaviour in public. Conversely, the Victorian Crimes Act 1958 sets out most of Victoria's indictable offences. Examples of indictable offences include rape and murder. Finally, examples of indictable offences heard and determined summarily include theft of under $100,000 and theft of a motor vehicle. Now, a common SAC or exam question that you might be given is one that requires you to explain whether a particular offence is a summary offence or an indictable offence. On this slide, I've set out a table that you can use to identify whether an offence is a summary offence or an indictable offence. Please copy this table into your summary book. In determining whether an offence is a summary offence or an indictable offence, you need to consider the seriousness of the offence. As you know, more minor offences are summary offences and more serious offences are indictable offences. In judging how serious an offence is, you look at the maximum punishment for that offence. If the offence is punishable by up to 2 years imprisonment or is not punishable by imprisonment at all, then it will be a more minor offence and therefore a summary offence. As you also know, summary offences are heard in the magistrates' court where there is no jury, whereas indictable offences are heard in the county court or the trial division of the Supreme Court where there is both a judge and, assuming the accused pleads not guilty, a jury. This is because it is the role of the jury to determine whether a person who pleads not guilty is in fact guilty or not guilty. Just a little point to note here, which I will reiterate in the next video. This is that proceedings in the magistrate's court to determine whether an accused is guilty are called hearings, but proceedings in the county court or the trial division of the Supreme Court to determine whether an accused is guilty are called trials. Another factor to look at in determining whether an offence is a summary offence or an indictable offence is the legislation or statute that creates that offence. If the offence is created under the Victorian Summary Offences Act 1966, then it will be a summary offence. If the offence is created under the Victorian Crimes Act 1958, then it will be an indictable offence. Finally, if an accused is charged with an indictable offence, then they will have to attend committal proceedings, and in particular, a committal hearing. I'll explain what is involved in committal proceedings in the next video, but for the moment, just remember that if the accused attends committal proceedings or a committal hearing, then the offence that the accused has been charged with must be an indictable offence. If the offence is a summary offence, then there will be no committal proceedings or committal hearing. Let's now put this information into practice by answering the question on this slide. The police charge Samira with stalking Rishad. Stalking is an offence under Section 21A of the Victorian Crimes Act 1958 and is punishable by up to 10 years imprisonment. At her committal hearing, Samira pleaded not guilty, and so her case proceeded to trial in the county court. The jury that heard the case decided that Samira was guilty, and the judge sentenced Samira to 18 months imprisonment. You're asked whether Samira was charged with a summary offence or an indictable offence. Importantly, you are asked to give one reason for your answer. Now, where a question asks for one reason, you must just give one reason. If you give two reasons, then you will only be marked on your first reason, and so you will have wasted time and effort by explaining the second reason. Well, Samira has fairly obviously been charged with an indictable offence, but make sure that you answer the question by writing this. Then we come to the reasons you can use to justify or explain your answer. There are 5 reasons you can use, but remember that the question asks for one reason, so you must choose one of these 5 reasons. Well, first, Samira's trial was held in the county court, and the county court only hears indictable offences. Note the use of the word only. This is important because otherwise you are not making it clear that the county court does not hear summary offences, and so this must be an indictable offence. To really nail your answer, I encourage you to include the counterfactual. If Samira had been charged with a summary offence, her case would have been heard in the magistrate's court. Second, Samira's trial was held in front of a jury, and a jury is only used for indictable offences. Again, note the use of the word only. This is important because otherwise you are not making it clear that a jury is not used for summary offences, and so this must be an indictable offence. Again, to really nail your answer, I encourage you to include the counterfactual. If Samira had been charged with a summary offence, she would not have had a jury trial. Third, an indictable offence is a more serious criminal offence, whereas a summary offence is a more minor criminal offence. This suggests that stalking is an indictable offence because the maximum punishment for stalking is 10 years imprisonment, which is clearly a very severe punishment. Note that the fact that Samira was only sentenced to 18 months imprisonment is irrelevant to determining whether the offence of stalking is serious. The seriousness of an offence is judged by its maximum punishment. As I've said, if the offence is punishable by up to 2 years imprisonment or is not punishable by imprisonment at all, then it will be a more minor offence and therefore a summary offence. But that is not the case here. Fourth, stalking is an offence under Section 21A of the Crimes Act 1958 of Victoria, and all of the offences in the Crimes Act are indictable offences. Fifth and finally, Samira had a committal hearing, and a committal hearing is only used for indictable offences. Again, note the use of the word only. This is important because otherwise you are not making it clear that a committal hearing is only held for an indictable offence and not a summary offence. To really nail your answer, include the counterfactual. If Samira had been charged with a summary offence, she would not have had a committal hearing. Well, that brings us to the end of this video. As a result of watching and taking notes on this video, you should now be able to do two things. First, you should be able to define the three types of criminal offences. These are summary offences, indictable offences, and indictable offences heard and determined summarily. And second, you should be able to distinguish between summary offences and indictable offences. Don't forget that you now have to read the pages of the textbook referred to on the first slide and supplement your notes with any additional information from this reading that you think would be useful. Thank you very much for your attention.